Lucido Manzella PC, Clinton Township, Michigan law firm, recently shared some thoughts regarding the effect of Defense of Marriage Act ruling on immigration and bankruptcy benefits. On June 26, 2013, in a monumental decision, the United States Supreme Court ruled that the provision of the Defense of Marriage Act which prohibits the federal government from recognizing same-sex marriages is unconstitutional. In practice, this means that married same-sex couples cannot be denied the same federal benefits which are afforded to legally married couples, including immigration and bankruptcy benefits. The United States citizens and legal permanent residents are able to sponsor their foreign national spouses to become green card holders and eventually citizens of the United States. Since Defense of Marriage Act was signed into law in 1996, these immigration benefits have only been available to foreign nationals in heterosexual marriages. According to recent statistics, there are an estimated 36,000 same-sex married couples who are now eligible to file for these benefits. Lucido Manzella, PC, also shared same-sex couples will soon get federal immigration benefits. Supreme Court strikes down Defense of Marriage Act as unconstitutional. In a historic move, the United States Supreme Court on Wednesday struck down as unconstitutional the Defense of Marriage Act, which was signed into law by President Clinton in 1996. Defense of Marriage Act defined marriage as only between a man and a woman. As such, Defense of Marriage Act denied to legally married same-sex couples the same federal benefits provided to heterosexual spouses. Under Defense of Marriage Act, Social Security, pension and bankruptcy benefits, along with family medical leave protections and other federal provisions, did not apply to gay and lesbian couples legally married in states that recognize such unions. The Supreme Court was presented with the issue whether Defense of Marriage Act violated equal protection guarantees in the Fifth Amendment's Due Process Clause as applied to same-sex couples legally married under the laws of their states. The majority of the court found that Defense of Marriage Act violated the Constitution. The Supreme Court was divided 5-4 in its decision. But there's more, according to Peter Lucido, Michigan attorney, as set out below. Now that Defense of Marriage Act is dead, the historic ruling will open doors for immigration for same-sex married couples. Defense of Marriage Act prohibited married same-sex couples from collecting federal marriage benefits, such as the ability to petition for his or her spouse to become a permanent resident. This means a United States citizen man or woman who is married to a same-sex partner will now be able to petition for his or her spouse for adjustment of status, if in the United States, for consular processing, if the spouse lives abroad, or a fiancé petition to bring the partner to the United States for the purpose of marriage in a marriage equality state that recognizes same-sex marriages. Department of Homeland Security Secretary Janet Napolitano praised the Supreme Court ruling. This discriminatory law denied thousands of legally married same-sex couples many important federal benefits, including immigration benefits, Napolitano said in a statement. Working with our federal partners, including the Department of Justice, we will implement the Supreme Court's decision so that all married couples will be treated equally and fairly in the administration of our immigration